Hey everybody, Arizona attorney David Ian Wilson here, and in this video I want to talk to you a little bit about challenges that somebody can make to a prenuptial agreement. Now, understand before we get into this that this kind of cuts in two directions. So at the same time as this can be ways that you can challenge the validity of a prenup after it's been entered into, simultaneously this is going to provide mechanisms by which you can enforce or make stronger or kind of make more bulletproof the prenup if you're doing it on the front end, you're doing it prospectively. A couple things we can look at are disclosures, coerciveness, the issues that you're putting into the prenup, and the validity of the prenup as it relates to third-party creditors. First off, disclosures. Now, generally speaking, we're talking about Arizona law here, and this also applies to most other states, but to the extent I'm licensed anywhere, it's Arizona, so I'm talking specifically about Arizona family law here. One of the things that you have to have in a prenuptial agreement is disclosures. So you have to know that everybody knows exactly what they're entering into, what they're giving up, all of that sort of thing. So one of the things that you want to make sure to do as you're signing the prenup and attaching things into the prenup is to verify that you've got full financial disclosures. Now that means kind of tell the other party what all your assets are, what all your debts are, what your financial situation is. Typically you'll have attachments to the actual prenuptial agreement document that have schedules of all of that stuff. So one thing you want to make sure to do if you're creating the prenup is to add all that in, make sure that it's very clear that there were disclosures there. On the other hand, if you're trying to challenge the prenup, then that's something you can target if that didn't happen. So if there wasn't a full and complete disclosure, that's possibly an angle you can take to attack it. The second one is coercion and duress. Now, anytime you have a prenuptial agreement, you have to verify that it was entered into freely, voluntarily, there was no zero coercion, duress, that kind of thing. So one of the examples I like to give people is of, say you have this big wedding and everybody's come in from out of town, all your friends and family have spent tens of thousands of dollars on the venue, the wedding, everybody's spent a fortune on plane tickets and hotel rooms and they're taking time off of work. It's this huge deal, right? You're there, few minutes before everybody's about to go out into the ceremony, husband runs into wife, and of course this could be the bad luck part, but runs into wife and says, here's a prenup, sign this or everything's off. So wife does, or future wife does. Now in that situation, it's pretty easy to argue that there was a lot of coercion going on. That is to say, wife seeing this thing, knowing all this stuff is happening and thinks, oh my gosh, I've got to sign this thing or I'm completely screwed, all these people are going to be upset, all this money is wasted. So she's not really having a fair shake at this, in this idea. So if you have a situation kind of like that where it's coercive, then that's a way you can challenge a prenup. Now, ways to insulate against that are things like, for that sort of a situation, make sure you've got plenty of time before the wedding in which you're signing this. So if you're doing it minutes before the wedding is about to happen, that could start opening a door to that kind of an argument. Insulating against it, just make sure you've got some time. Do it as far ahead of the actual wedding as you can. Some similar things that you can do to sort of insulate against that, or if these things didn't exist, that this can create some potential hole that you can attack in the prenup, is to record how things are happening. So if you're doing this, the actual signing of the prenuptial agreement, you can videotape it. Set up your phone recorder or some camera or something so that you can film everything that's happening. Now, if you've got a situation where everybody's happy and smiling and kind of running around, it's going to seem a lot less likely that there is a coercive situation going on. So having that film in place can be one more layer to preventing somebody from coming back later and challenging it. Now again, converse to that is if you don't have one of those things, that could maybe open the door a little bit to saying this coercive environment existed. Similarly, you can have a situation where there is a court reporter involved. Now, a lot of people will take the signing of the prenuptial agreement, they'll sit down and they'll have each party asked a bunch of questions in front of a court reporter, so it's under oath, and you're saying things like, are you signing this freely, voluntarily? Have you had any drugs before this? Is there plenty of time? Have you had a chance to consult with an attorney? Or do you have an attorney here? And so you can kind of go through all these things and it makes it a little clearer that this person wasn't under duress. Now here again, if these things don't exist, this can open the door to some kinds of challenge. Finally, the last thing I've sort of alluded to in this one, in terms of the duress and coercion situation, is having attorneys. Now, generally speaking, you've got an adversarial system when you're dealing with prenups. So if you have one party is represented by an attorney and the other one isn't, that also can start to seem like it's a coercive situation. So ideally, this isn't required, but ideally on the front end of it, to look at the prospective side, you want to make sure that both sides have attorneys, because then it's much harder to argue that one person didn't know what was going on, or they were kind of being bullied into signing something like that. If you can say, well, they were both represented by attorneys, like they had a full opportunity to object to things or to put their will out there, and so it's much harder in that situation to argue that you were forced into it. Another major thing, other than the duress, coercion, the full disclosures, is what the substance of what you're putting in there is. Now, generally speaking, with a prenuptial agreement, you want to ensure that you are just dealing with financial issues and property issues. And those things are just limited to what's going on directly between the two spouses. So for example, you might waive things like spousal maintenance, or talk about how you're acquiring property, what the nature of that property is going to be. Is it going to be separate or community, that sort of thing. That's the stuff that's typically in a prenuptial agreement. Now, a lot of people try to put in other things, and this can start to get dangerous. One example is child issues. Now, a lot of people will try to go, I want to waive child support if we have children down the road. That's a bad idea. You don't want to put that in there because you can't legally do that. You can't waive prospectively child issues such as waiving child support or altering parenting time when you don't even have the child, especially because family court is always going to retain jurisdiction over this third party whose interests are being impacted by all of this, and sometimes even the state, because if, for example, one of the parties has to go on welfare after the fact because one party's got a ton of money and the other one's just waived everything, now all of a sudden the state's having to shell out welfare money for this child. So for a range of reasons, you can't just wipe out child issues by contracting between the two parties. So by putting one of those things into a prenup, you're actually creating some jeopardy to the validity of the prenup. So completely leave that stuff out. Similar one that people will try to put in is stuff that doesn't have anything to do with financials. The example I like to give is, because I've seen this, is a situation where, let's say, in the prenup, you're trying to say that, okay, every week husband promises he's going to take out the trash, and in exchange, every week wife assures that she's going to perform some sort of sexual favor. Obviously, that creates some problems, at least this is obvious in my head, because you're essentially contracting for sexual services and servitude. So those are illegal and unconstitutional in the United States. You can't force someone into these kinds of situations. Now, when you inject that into your prenup, you're creating, again, some sort of jeopardy that the whole thing is going to be deemed to be void. Additionally, we have kind of a long-standing tradition, legally speaking, that anything that's in a prenup has to promote good morals and that sort of thing, which here I think there's a pretty strong argument that that wouldn't be the case. So when you're drafting the prenup, make sure that the only things you're putting in there are financial stuff or property stuff. Doesn't have to do with children, and that's kind of it. On the attack side, if you've got some of those provisions in there, that can be something that you can use to challenge the validity of the prenup. The last one on the list is related to third-party creditors. Now, one of the major benefits of having a prenup is that even without talking divorce, it can impact what's happening on the property within the relationship. So that can be used to protect your spouse because it insulates your spouse's property from your property. And so if a creditor is chasing you down, then they can't attack your spouse's property. The catch to that is you have to perfect it, and that is to say you have to put all the rest of the world, all these potential third-party creditors, on notice of the fact that you're not operating under this normal property system that we would have during marriage, which in Arizona is a community property system. So if you don't file and timely file a what they call notice of signing with the county recorder's office, the creditors are never going to know that this thing is out there and have no reason to know that you've got this prenup signed, and so they could potentially not be bound by the prenup. So if you're in a position of being a creditor, that's one of the first things you want to look at. Did this person that you're trying to attack in terms of their property, did they have a notice of signing that was properly filed and timely filed? If not, that's a vulnerability in the prenup. Conversely, if you are signing a prenup and you're putting one together, you want to make sure that that thing has been filed. So as you can see, there's a whole range of potential traps. There's a whole range of potential challenges that you can make to a prenuptial agreement. As always, with all of this stuff, I strongly encourage that if you're looking at a prenup, either to challenge one or just to create one, you should definitely speak with an attorney that is licensed to practice in your state, and specifically that works in the area of family law, because family law alone can be very confusing. There's a lot of different variables. So talk to an attorney if you want to find out any more information about any of this, or if you want to draft a prenup or challenge a prenup, and make sure that you're protecting your rights.